arms will get tired.
Right. Okay, well, thanks everybody. This is a surprise in two respects. One, I hadn't anticipated re-upping for round 6 or 7 of the probate modernization work, but it's great to be with you all. And number two, kind of a new medium for us to try out. I'm really curious when this stay-at-home stuff is all done, how, and we've all gotten used to these kind of meetings, how common it's going to be to continue with these kind of virtual meetings as we all get better with them and the technology improves. But this will be our first one, so bear with us all. If you're on the phone, feel free to unmute yourself. You'll just have to break in since we can't see you. But when you speak, please identify yourself each time so we know who you are.
And Lane, really quick, this is Sandy. If you weren't here initially, if you're on the phone and would like to mute yourself and unmute, you can use *6.
Okay. All right, let's begin. First of all, thank you everybody for joining us. Your interest in continuing on with this. Maybe Sandy, do you want to tell us a little bit about the Law Commission's charge with respect to Chapter 111? And then Jennifer, do I turn it to you to speak to generally the draft? Do you want to lead that, or Heather, one of you two anyway? But Sandy, why don't you go ahead and just kind of talk generally about what the Commission's charge is with respect to Chapter 111?
Sure. The Commission took this project on Chapter 111 as a continuation of the charge that was already within the Probate Modernization Group. There was no new charge necessarily. This is a group that's been ongoing for since 2013 in one form. It was brought up, Heather and Jennifer, and I know Judge Cobb worked on it, and potentially some other folks, I don't mean to leave anyone out, had worked on this independently, the section for Chapter 111 as a draft, brought that to the attention of the Commission. At the last Commission meeting, which we actually held remotely a couple weeks ago, the Commission agreed, we didn't vote separately on it because it was already an approved project, but agreed that this group could take on that project and continue with our work for Chapter 111.
Sorry, you froze there for a while. I missed some of that. So, something about the Law Commission having met remotely.
Yes, the Law Commission met remotely, and it was not a new project, so it was more of an agreement to continue the work of the Probate Modernization Work Group. They all had a copy of the draft. Heather came on the remote meeting that we held and talked through what the project would be, and the Commission agreed to allow the probate group to move forward.
Seems pretty straightforward. Heather or Jennifer, do either of you want to talk just generally about what your thinking is on this draft before we get into it section by section?
Jen? So this is Heather. What we did was, as we were going through the other sections that the Probate Modernization Committee worked on, we decided that we also needed to look at 111, because 111 as it's currently enacted doesn't really reflect anything like how probate works. And so we wanted to make it a practical statute about really how do the procedural things in probate occur. And then we wanted to improve it to have some of the things similar to 125 that are helpful to attorneys. So if you look at the draft, we tried to identify what were policy questions, and we spent a lot of time on the old distinction between probate courts and circuit courts. And so we had to do some research on that, and we talked to Warren Darris, and we looked at the old, there's another, I'm sorry, I can't remember off the top of my head, there's a courts section that talks about the probate courts. But for the most part, we don't need the transfer of probate jurisdiction anymore. That transfer of probate jurisdiction was for a purpose that is no longer relevant. So if you look at that, that's what we took out. And then we described what we wanted the court, what we think the court already has the power to do. But when we use those references to the court's authority, those of us who do that can't always find the exact statute. We know that the court has the right to do it, but oftentimes the specificity of the authority isn't as clear as we would like it to be. And we also tried to do the same thing with the powers of the court, like in 125. Probably the place that we spent the most time was dealing with the problem of the Oregon Evidence Code and the ORCPs, because they're totally distinct from ORS 111. And we leaned heavily on Brooks Cooper and Matt Whitman on that part to talk about when things became adversarial. Okay, I don't know why that's doing that.
Heather, there's some pretty serious feedback there. Let's try it again.
Can you hear me better?
Yep, that's better.
Okay,
Thanks.
that. So we looked at the Oregon Evidence Code. We tried to define when things become adversarial, because the way that it works in practice for experienced lawyers is we don't treat anything as adversarial. For example, it's common that you don't give people notices on things that aren't adversarial things, like your notice of affidavit of compliance with search for creditors. So we tried to define some of those things, and then we tried to define what procedure should look like. And if you remember, the old procedure statute just says there's no form required. So we're very, we added some things that we think are happening, and as we go through the statute, we can talk about those in specificity. They're already happening in the trust code or in ORS 125, and we think they're helpful over in those sections, so we added them to 111.
Okay. Thank you. Jennifer, anything from you?
Well, can you hear me?
Yes?
Oh, good. I figured it out. Basically the same thing that Heather had just said. We're trying to make it practical, match what we currently have, and try to be consistent with the trust procedures and the Chapter 125 procedures.
Is anyone hearing Heather?
I'm not talking.
I'm sorry, not Heather.
Well, I was done talking.
Oh, Jennifer. Oh, okay.
Yeah.
I think you might have broken up just a little bit before you finished. Okay, well, that's fine.
Okay.
Then, does anybody else that's want to speak to generally to this before we jump in section by section? All right. Then then let's do it. You have in section 111, 105 or 005 definitions for probate law, and a question here: should we define the term probate? I guess my question in response to that is that a problem?
This is Judge Cobb. Remember, maybe my memory is failing me, but didn't we talk about this a while ago under the rest of the probate modernization group and decided that we didn't want to? Or am I not remembering that correctly?
I think that is correct, Judge. But I guess this is a chance to revisit that. I guess, does anyone want to speak up for defining probate? And I guess first make the case for what we're missing in the law right now without a definition of probate.
Well, this is Jennifer, and I think the reason that we included this in the draft was this particular chapter does refer to probate a lot. We do have the term probate court defined and the term probate proceeding, which are also used a lot. And maybe this is a question we could defer as we go along. Maybe it doesn't need to be defined.
And and I'm happy to defer it. I think it makes sense basically to see if there's anything that we're dealing with here that could be improved and when we get into the substance with the definition of probate, which again we've never had. Does anybody else want to speak to
This is Gretchen.
Who's that?
This is Gretchen. I
Yeah,
heard
Gretchen.
someone else. Is someone else? We do have the description of probate jurisdiction described, and it has the list of everything that is covered. So I would think that that could satisfy that need to have a definition, in that it's kind of already defined with the list of what it covers.
Right. Yeah, I think that's kind of where we were the last time. We don't have so much a definition, but we have a description of probate, which seems to have worked. But I'm open to it. It's been presented, so let's park that, I guess, unless anybody else wants to speak to it now, and we'll see as we go through it if it would be helpful. Who's that?
This is Judge Burton. I would like to say something. And I do not have the other statute in front of me. So this may not be an issue at all, but so we're excluding protective proceedings from the definition of probate, but then the probate commissioner is allowed to sign judgments appointing fiduciaries. So I just want to make sure that we're not somehow removing the probate commissioner's ability to appoint guardians and conservators.
Okay, I think that would not be the case, because somebody tell me,
This is Jennifer.
What's that?
This is Jennifer, and under ORS, in the draft, under ORS 111.085, 1G, it includes guardianships and conservatorships under probate jurisdiction.
Okay, so it doesn't matter if we take them out under 111.005?
I don't think we're proposing to.
Those were what we did there on 005, where we raised questions about whether we should add new definitions. If you look just under 111.005, it says add new definitions. Should we define probate? Should we talk about what the probate court is? Should we define what a probate proceeding are? Those are questions.
Yeah, so Judge, I think at this point, there's no suggestion to remove that specific mention of guardianship and conservatorship in 111.085.
Well, this is Jennifer, and also the purpose of Chapter 111 is to deal with probate procedure, and Chapter 125 already deals with Chapter 125 procedure.
Right.
Okay.
Yeah, so my sense is we're okay there. Let's move on to the repeal of 111.055. And I remember when we went through Chapter 111 in our first walk through the probate mod group, we had a discussion about this and ended up leaving it in, and I think it was an LC decision. I mean, I agree, it looks transitional to me. And I don't remember why we were persuaded to leave it in. Lori, have you thought about that, or maybe something you could think about? I don't think there's any. I don't have a strong policy reason to leave it in. It looks to me like it's been accomplished, but does anybody know?
So this is Lorianne, and I can check with Marisa to see if she has notes on why it was left in and get back to you.
Okay.
I know that we talked to Warren specifically about this because we recalled that we had decided to leave it in because we weren't sure, and we wanted to be protective of the concerns of Gillum, Grant, Harney, Malheur, and Sherman and Wheeler counties.
Right.
But then after we talked to Warren about it, Warren said it was no longer needed because that was purely transitional.
It looks like it.
But I think out of respect for those counties, it'd be interesting to have someone ask someone other than Warren, but Warren's usually right, or not always, but usually right, so.
Well, certainly those counties are respected in 075, which we're leaving in. So yeah, I don't think it's a big policy question. I think it really is more a matter of legislative counsel. So Lorianne, if you could check on that and see if Marisa has notes as to why we didn't take that out the first time. Again, I don't think it's a big policy question. The bottom line is we're not contemplating removing probate jurisdiction from those county courts in those counties.
Okay, I'll do that.
Okay. All right,
Lane?
so 075.
Lane, this
yeah.
is Jennifer.
Hi,
You know, it
Jennifer.
might help if I give a little bit of background on how this text is presented, because you know, it's not presented in the usual LC way that shows crossings out and additions of text.
Okay.
It's
Please.
really kind of presented as this is what we think the statute should be. So some of it is copied from the existing statutes. And in some places, like in .075, I say at the end,
Yeah.
adding related, you know, I give some basis, but it's not, you know, so this is the proposed language. It's not, you're not necessarily seeing the additions and deletions to what's existing.
Okay, yeah, and that actually helps answer a couple questions as I was reading this. So we're going to depend on you or Heather or somebody who was in the drafting to identify for us new language as we go through, if it's not already identified the way you've done it here in this note to 075, so we are clear as we look at as we look at this draft, what is new, or
Well,
what's being taken out.
and Lane, what we could do, and if I had planned ahead better, I would have done this. I could do a document compare in Word that would show all of that.
Yeah, that'd be really helpful if you could do that.
Yeah, I'll do that.
So for today, we'll go through it and hope and try to ask you to identify the changes, either additions or deletions. But so the question is, we have the addition of related. And again, you're thinking there again, I guess it's in the brackets. That just it harmonizes it with other statutes. Is that it?
Well, this is Jennifer. And so if I'm just looking at the current version of .75, and I believe what has changed is where it says probate related.
No, Mark,
Where it says it added the word hyphen related.
Right.
And then all of the rest of the statute appears to be the same. So that's really the only change, I believe.
Does anybody have any feelings about that?
This is Mark Comstock. I have a
Yeah.
question, and that is, if there's a let's say an in rem foreclosure of a property that is arguably in an estate, there's a statute that in the foreclosure statutes that allows an in rem proceeding to go forward. Would that be a probate related proceeding then under this proposal in 085? And if so, you're changing a lot of the, shall we say, ORCP procedures and ORS procedures by changing your application of ORCPs and ORSs.
So this
Yeah,
is
go ahead.
Judge Burton, and I would say no, because the foreclosure action is a civil action. The fact that the defendant or one of the defendants might be in a state. Sorry, that's my dachshund. You know, you wouldn't be making every action in which an estate is the defendant. You wouldn't be taking that into probate jurisdiction, I wouldn't think.
Well, and that's the reason that I raise it, because
Right.
the probate related matters is kind of squishy, I guess is the
Yeah.
best word I can think of.
So if you look down at 111.085, Mark, this is Heather
Yep.
Gilmore, sorry, 111.085.
Yeah.
So I'm looking at 1D, which describes what probate jurisdiction is. It's determination of title, rights in and possession of property claimed. So I don't dismiss your comment, because I think someone creative could try to do that. Do we have a better idea of how to say that, though?
Well, I'm wondering if we need to. Do we need related?
Well, the problem with that is, if you look at the current 111, it says jurisdiction of all probate matters.
Right.
And so I think the reason that we said probate related was because, Jennifer, do you remember, was it because of 125 and 130?
I believe the reason we said it was we looked at these other statutes for family and juvenile law and wanted to be consistent to those. I think that was what we were thinking. And also, there are related matters.
Yeah, there are.
Well, I guess that's the question, though, and that's a good question from Mark, though. Does adding related there really open it up? Are we creating an ambiguity that so that anything that relates to an estate, whatever the nature of the claim, now somebody has an argument is vested in a probate court or probate proceeding?
And just to highlight that a little bit, if I take the word probate related matters and let's just say I've got a non-judicial foreclosure going on, and I then need to change it somehow to name potentially a trustee or a personal representative.
Right.
Does the addition of probate related and the addition of 111085 sub what is it, D, now turn that into a judicial proceeding as opposed to the non-judicial? I'm kind of spitballing it here, but
Yeah.
I'm, shall we say, a little bit confused and want to make sure that it's fully thought through.
Well,
Yeah,
this is
so-
Jennifer. This is Jennifer, and as to one point that you made, Mark, the .085 1D, that's currently in the statute.
Okay.
It's Heather, it is in the statute, but if you compare the statute, it's just probate matters.
Right.
We made it probate related. And part of what we're trying to do here is there's a lot of things that occur in the probate court, and some of it we're trying to clean up and simplify. For example, we have this big issue in probate when one of 5 heirs is in possession of the property because they're a basement dweller. Which I know there's legislation to try to change that, but it's a real problem in estates to have to separately file a suit to try to remove the person who's either been the elder abuser of grandma or just the person who really has no rights and grandma just couldn't get him out.
So this is Judge Bertner. I would throw out another very common example of related, and that's where you have a conservatorship case, and then you have a civil elder, usually financial abuse case. And I have been doing those separately because the civil case is entitled to a jury trial.
Right.
So yeah, that would raise a question along the line of Mark's, is if you add related, are you then bringing those all in?
Can I jump in here? This is John Dranius.
Yeah, John.
I just got here. I've only been quiet for a little while. Sorry, I was late. We have a case that we're bringing. I think we're filing it tomorrow. We think that the personal representative of an estate has engaged in tortious of conduct in the course of administering the estate. We're filing that in federal court. We don't think it's a probate matter, even though she is the personal representative and it does involve the administration of the estate. That would, I would think, arguably be a probate-related matter, and as a matter of specifics or semantics, if it's probate-related, it's not probate.
Yeah, let me say, I guess I would just be concerned that by this we're actually injecting some, rather than clarifying it, we're actually injecting ambiguity and uncertainty by that expanded related.
I think we are, because you've got differences. I mean, you know, probate courts are wonderful in some regard, but they're the worst court you could ever be in others. The last person we would want handling this tort claim would be a probate judge.
And like Judge Burton says, some of these things, some of these other claims that may be related to probate might involve the right to a jury and those kinds of things, and that really complicates. Well, it's not workable.
Right, and I appreciate the need. I appreciate the need for a simplified procedure to get people out of houses, but we can't let that tail wag the whole dog.
And this is Brooks. The claim John's talking about would absolutely have a jury trial overlay for probably most, if not all, the claims. And I, as a trial lawyer, rarely am willing to waive that absent a very, very unusual reason. So there's that.
So John, is that you again? Nope.
Oh, that's okay. Go ahead.
That was Brooks from John's office.
Oh yeah, no, I got that. Yeah, I just on my screen I saw somebody else's box light up. I thought that John was trying to get back in.
Oh, how wild. I just called in. I didn't know that worked that way. That was late and I didn't have time to figure out how to make Zoom work.
It's
is that like I raised my hand?
That's right. Well, my sense is to say no unless somebody can make a really strong case that this actually improves and clarifies. My concern is that it creates some uncertainty and ambiguity.
Agreed.
All right, so let's go on. Is there anything else in 075 that's new, Jennifer, Heather?
No, I believe that's the only thing. So we would just take out the hyphenated related.
Okay. And the same thing in 085, just since they describe the same thing. Take us through 085 and is there anything new? There is. Okay,
So this is Jennifer, and so the first one all through H is I'm checking quickly, but I believe that's all the current statute. And then I actually, the current statute, the current statute just says appointment of a successor testamentary trustee where the vacancy occurs prior to or during pendency of the probate proceeding.
Uh-huh.
And this wording, I believe, I can't remember why we made these changes, but we had a reason for clarifying the current wording.
Well, it looks like what you've added then is the ability to appoint a testamentary trustee if the will doesn't name one. I don't have the current version of 085. Would that be the new language?
Right, yeah, if the will doesn't name one, because it says where the vacancy occurs,
right,
and there may not be a vacancy. Maybe that was what we were thinking.
Maybe it's vacant because there wasn't a nominee or a trustee appointed.
Exactly, or the trust never existed, so there was never a vacancy, and then the nominated person was dead or something.
Anybody on that? That seems to make sense to me. And it might even be already implicit in what the statute provides, but I think this is a case where the extra words do clarify. Who was going to speak up there?
Oh, it's John. I think that would be a streamlined thing. I mean, why have to bring a separate proceeding to appoint a trustee?
Okay, so are we good on I?
This is
All
Matt
right.
Trump. I have a comment about a different portion.
Oh, yeah. Who's this?
Noticing that in the first sentence of paragraph 1 in the draft reads the jurisdiction over probate, and we'd take out related.
Right.
Probate matters includes but is not limited to. The current statute reads jurisdiction of the probate court. And going back to some of, I think it was Judge Burton's comments about what the proposed definition of a probate proceeding and how that might impact Chapter 125. I think this is worth some further consideration to make sure that we're maintaining clarity. And one possibility that I'm seeing is that potentially we might have probate proceedings that are related to the administration of the estates of deceased persons, and the Chapter 125 is already defined with the term protective proceeding. And I was looking in Chapter 125 to find where in 125 it talks about what courts those are vested in, and it just relates back. It's in 125.015 and provides that the probate courts and commissioners provided for in ORS Chapter 111 have exclusive jurisdiction of protective proceedings. So that's where the probate court, as we think of it, is being used to have jurisdiction over protective proceedings also. But there's a lot of potential disconnect between the specific statutory language and what we use in more everyday parlance, which is to think of the probate court as the court that handles estates as well as estates for conservatorship estates and guardianships. And maybe we want to try and, as we're updating this, make those clarifications a little more distinct. So in one sense, I'm thinking that a definition of probate proceeding and then changing 111.075 to just refer to jurisdiction of probate proceedings, and maybe the same in 111.085, jurisdiction over probate proceedings includes. I'm not going to put my foot down and say that has to be the thing, but it's something to think about as we go forward on this, I think.
This is Heather. One of the things that we have to remember about our current ORS 111 is probate court is not what we all use in parlance. Probate court specifically means those courts in Gillum, Grant, Harney, Malheur, Sherman, and Wheeler counties. It's a weird thing that's left over in 111. And so as Jennifer and I worked through this, we were trying to get rid of that old conceptual idea that the probate courts, which for those of you who aren't familiar with it, they're not necessarily lawyers or real judges. They're lots of other things that run those courts.
So going back up to 111.005,
Hi,
Heather, is circuit court in the definition of probate court, is that new?
Yes, that's an added definition.
All right, yeah, we need to see that in a compared format.
This is Lori Ann, and I just want to point out that probate court is already defined. It's under 111.005 sub 7. So it's court or probate court, means the court in which jurisdiction of probate matters, causes, or proceedings is vested is provided in 111.075. So I think this is already addressed in statute.
Okay.
Yes, but that is the probate matters. When we fixed it right. But if you look at the current 111.075, you get there. That's the vesting. Well, I guess that is vesting in both. But if you look, as you read the statute, jurisdiction in 111075 is correct, but references in the old 111 are consistent with probate courts, meaning those Eastern Oregon counties. And it goes back and forth. It's not, that's one of the things we tried to clean up because it was such a mess. So if we do something, we just have to continue to be, I mean, I'm not wed to anything other than making sure we don't continue to have this back and forth between, is the probate court just the Eastern Oregon counties, or is the probate court one of the Eastern Oregon counties or one of the circuit courts exercising probate jurisdiction? That's why the new definition is helpful.
Well, Lorianne, could you take us again through that language you were just reading? It's not in the draft that we have.
Yeah, so that is, it's 005 sub 7, and that is court or probate court, means the court in which jurisdiction of probate matters, causes, or proceedings is vested as provided in ORS 111075. So if I'm understanding you correctly, what the concern is that there could be other places in 111 or throughout the probate code in general that refers to probate court with the intention of limiting it to those specific counties that the circuit court is not the probate court. Is that what you're saying?
Correct, that's the problem.
So what if we went through and instead addressed those? I mean, that, I don't know where those instances are. I would have to do some going through the code entirely. But it might be worthwhile actually addressing those instances rather than, because I think the definition of probate courts that you're advocating for is actually the definition that's in statute already.
Sounds like it.
Essentially.
I think that's right. Although I think it's a good idea to be mindful that as we go through and see if we do need to clarify. But Lorianne, it sounds to me like you're right that we have that already.
Here's why we had to do that. I just found it. I knew there was a specific reason. The current 111075 refers back to 111-115, which is the transfer of estate proceedings from county court to court. Because we got rid of 111-115 as antiquated, then this statute 111-075 also changed.
Well, no, 115 isn't a transfer of jurisdiction. It's a transfer of a proceeding.
Oh, a proceeding. Okay, sorry.
Right.
I can't remember why we did it then. Sorry about that.
Yeah. Let's go on. I think without making.
Well, this is Jennifer, and
I is under question, at least in this draft, because I think we may have already nailed it.
So this is Jennifer, and I think you're right. I don't know that I had noticed that definition in .0057. So I think that's right. But I liked the comments that Matt made about jurisdiction over probate proceeding. That to me has some appeal, and because probate proceeding is a defined term.
Right. Lorianne, do you know, does it make a difference where we have, or not just Lorianne, or you on the spot, but anybody, we have a defined term, probate proceeding. Well, if we use that, I guess. Seems like if we define it, then we would want to use it.
Yeah, I'm just trying to figure out if this ends up being circular.
Yeah.
Because you're having a lot of cross references that I think are unnecessary if we combine it into one thing. So basically you're saying in the definition, the proposed definition of probate court, you're cross referencing saying,
well, I think we're going to take that out though.
Court. Oh,
I think
we
we're
are
going
going
to
to
take
take
out
that
the
out
proposed definition
Okay.
of probate court.
and then just have probate proceeding defined.
Well,
But
and
I think the comment had to do with changing the definition of, sorry, I'm going back and forth in my notes and getting a little lost. I actually, in my notes, I had questioned why the definition defining probate proceeding was necessary.
Yeah.
Because I'm not entirely sure that it adds a whole lot, but I could be missing the point.
So this is John. What's a probate matter or a probate cause as opposed to a probate proceeding?
Well, probate proceeding is the process, isn't it? The matter is the subject of the process.
Okay.
Which to me
What's a
says
cause?
matter is probably a proceeding.
What's a probate cause?
Where do you see cause?
075.
Oh,
I mean, this is the proposed new statute and the old statute have this in several places. They refer to probate matters, causes, and proceedings.
Well, and this is Jennifer, and I believe the reason we added probate proceeding is because we've used it in several places later in the statutes. I think that's, you know, we did this a long time ago, but I think that's
No, you didn't add it. It's already there.
Well,
It's in the existing statute.
Right, and I don't know. For me, and it may be based on Judge Burton's earlier comment that we do want to add Chapter 125 in there, or even Chapter 130. I don't know, but I think that's why because we have used the term repeatedly. It seemed like it would be a good thing to define, and then maybe we can leave out matters and causes and just have probate proceeding, which is a defined term.
well, but again, I guess back to my question, which is sort of devil's advocate on this. Is there some confusion? We're not writing this from scratch, so we have a long history with this statute and with probate proceedings. Is there a problem that we've encountered in real life with courts by not having probate proceeding defined?
Lane, there was some interference on there. Could you repeat your question?
Oh, yeah, just basically the question I've got is since we're not writing this from scratch, but we have a whole long history with this, is there a problem that the current law has by not having a definition of probate proceeding? Has that created issues in the courts or in practice that we need to solve by defining probate proceeding?
I don't think so.
Hey, Lane, this is Brooks. When I read that as a trial lawyer, that to me reads like an echo of the various fully synonymous words that have been used in older case law. You'll find cases that talk about litigation as a cause. You'll find things talking about matters, and then things within causes and matters are often talked about as proceedings, what we'd call hearings today. At least as a trial lawyer, that doesn't cause me any heartburn. I read that and say, oh yeah, that's no different than when we sign a release, we say, release, acquit, and blah, 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 blah,
right.
blah, blah, blah. No different, in my opinion.
This is Gretchen, and I'm sorry I got kicked out, and so I'm back in again. So if I'm repeating something that's already been said, I apologize. But probate procedure is defined in 111-205. It says a probate proceeding is commenced by the filing of a petition in a court with jurisdiction over probate proceedings. So, which is circular.
This is Jennifer, and actually the current 111-205 is quite different than what's there. And I don't know if you heard, Gretchen, you know, this kind of evolved where we were working on this draft and it got sent out. And so that this draft doesn't reflect all of the additions and changes to the current statutes.
You know, and I think we're struggling with that in the conversation today. I'm wondering if if you know, how far we want to go with this without having those particular changes identified. Because I think it is causing some confusion with this text reflecting changes that, you know, that is not identifying changes that are being made.
If we want to punt this to our next meeting, that's fine with me. This is Heather. I will just note as we go further, there's quite a bit of difference between the current statute and the draft statute.
Okay.
There's a lot.
I think our discussion would be a lot more productive if we had those changes in front of us, so we could all see what's being deleted or what's being added. How does everybody else feel about that?
Great. Yeah, my problem is I'm toggling between the online, you know, to see the current statute, because I'm just on a laptop, so I don't have two screens or anything.
Yeah.
And yeah, I agree. 111.205 is actually currently kind of scary looking.
This is Jennifer, and I wonder if it would be possible for legislative council to just kind of put this into their format. I guess that was sort of what I was thinking would happen.
Lorianne, would that be possible, just to merge this draft into the statutes that it's proposing to amend, and so we can see it in LC format with the usual italics and brackets and things?
Hi, yeah, this is Lorianne. I can put that together. When would you? I'm not going to be able to put it together for the phone call right now, though.
Oh, yeah. What, probably not for another couple weeks at least, I would say.
Okay. Well, I can have that for you probably next week.
Okay. Then I think we should do that. I hate to shut down some rich discussion, but I think we'd all be clearer as to it if we had that in an LC format, so we can see what's new and what's proposed for deletion.
Well, so this is Jennifer. Oh, go ahead, John.
John.
Yeah, another thing I'd find real helpful would be some editorial snippets throughout this that kind of explains the reason for the change.
Yeah. And
what problem is trying to be solved.
Yeah, I don't. Lorianne won't be able to give us that, and she probably doesn't want us playing with her draft once she creates it. So we'll just have to rely on the authors of the proposed amendments to explain as we go through. But again, that'll be a lot easier when we have a compared format draft in front of us.
Yeah, I think just some kind of a cheat sheet, so you know kind of what, because going through this word for word is kind of awkward, because some things are modified early because they have to be in order to affect something that comes later. So if we had some sort of a guide to what prompted the changes, that would be helpful.
The problem is that Jennifer and I have already committed an inordinate
redraft from Lorianne. Maybe you could do that, just as like John says, not in the document, but a cheat sheet.
What I can do is drop it into a Word document and then have comments with these, just copying over the proposed comments in this the rough draft that was prepared.
Okay, well, so at least we can preserve those comments.
And Lorianne, this is Sandy with the commission. If you send that to me in the Word document, I can distribute widely to members of the group.
Okay.
All right. So I tell you what, let's shift ahead. We've still got time here. Let's use it. Let's shift ahead to page 6. This page 6, that all is new. So we're not changing current provisions of Chapter 111. I mean, is that right, Heather and Jennifer?
Well, yes, it is correct. And also, if you look on page 4, the provisions that were just kind of whole cloth new. I used letters
Yeah.
with. And so 111.AAA
Yeah,
is
yeah, yeah,
new.
you're right. Let's go to 4 then, because that is entirely new material. Maybe one of you introduce 111 AAA to us on the bottom of page 4.
Well, this is Jennifer. Part of the problem that practitioners have is it's unclear from the current statutes whether the ORCPs and the evidence code apply. And some of the rules of procedure don't apply well, and it just creates all kinds of uncertainty. And so that was why we added this, and also the chapter 125 addresses this as well. And so we wanted to be consistent with that if we could.
Okay. So let's look at it and then we'll talk. The ORCP generally do not apply to probate proceedings except that the following ORCPs apply to adversarial litigation pending in a probate proceeding. And then we have
Lane, you're looking at page 6 instead of 4.
No, I'm sorry, we're on page 4.
No.
We're on page 4, 111 AAA. I skipped over that one as being an entirely new provision. So we'll need to look and confirm what all those rules are, but I don't want to do that right now. Let's talk about adversarial litigation.
Well, Lane, I can give you a little insight about all those rules.
Okay.
We did, Brooks and Matt Whitman did kind of look these things over, and we had a few little kind of interactions about those. And Heather's way more into the ORCPs than I am, but that was kind of where we came from. That was a source of identifying those rules.
Okay. But let's talk about just more the concept rather than the specific rules. So we're saying that these rules apply to adversarial litigation. And then we have a definition of adversarial litigation: any situation where a party seeks affirmative relief from the court, whether by petition or motion, to which another party has objected. Comments on that?
Lane, this is Brooks.
Yeah.
Has objected to me is important because that's intended to stop attorneys from filing, say, a petition for instructions and without any objection, instantly employing the subpoena process to begin conducting what would be discovery. If you don't have an opponent, you can't do discovery, and that's what we were trying to catch with that grammatical turn.
Well, and this is Jennifer, and in looking at this further, I think we also want to incorporate the will contest, and I'm not sure that has objected incorporates that. I mean, in that case, there would be an answer or something.
Actually, Jennifer, this is Brooks. The will contest itself is the objection to the petition filed by the PR. There is no answer required, but the mere filing of the will contest operates as an objection to the admission of the will and thereby triggers the adversary proceeding without need of further pleadings.
Okay, great.
Hey, Brooks, this is John. Are there situations where...
I'm not sure that it does in terms of the words.
Yeah, can I chime in? This is John. Brooks, are there situations where an objection might be lodged, but it really doesn't rise to the level of an adversarial proceeding as a practical matter?
I think you're right, but you give us an example.
I don't know. I'm just asking.
Oh.
I mean, is every single matter that has an objection a serious enough situation to merit being called an adversarial proceeding?
Absolutely. This is Brooks, because anytime person A wants thing to happen and person B says no, not thing or other thing, people's rights are being affected. That's, in my mind, no different than a will contest or a tort claim or a contract act. You know, people's rights are
Okay.
going to get adjudicated by a judge. That's adversarial.
Can I
Okay.
check?
All right, just asking.
Who's next?
This is Jeff. From the court's perspective, we consider it contested as soon as a second party gets added. So once someone has appeared in the case, either by objection, will contest, something like that, then we consider it a contested matter.
What about where somebody files just a notice that they want to receive notice in a proceeding?
That's not a contested
objecting to anything, but they
proceeding.
just file a notice statement
Notice of appearance?
that they want to be provided with notice of proceedings. Does that turn it into the whole thing adversarial?
No, that just adds them as a party that we're checking to make sure are included in all of the notices that are issuing.
Part of the challenge that we're trying to solve here is that we've had cases where there's obvious objections and litigation going on, and the other party entirely ignores the fact that it's adversarial and is communicating with the court is communicating back. I mean, so at some point we need to kind of clean that up, because probate is not a Sunday picnic. After somebody complains, we need to follow the rules.
I think that makes sense conceptually. In terms of the language under A, has objected. Do we really mean has filed an objection? Because it's one thing to send a letter or an email that says, I disagree, I think you shouldn't do that. But we really do mean filing something, don't we?
I don't know that, so the challenge with the probate court is just that, Lane, is if somebody sends a letter in, the court probably has some kind of affirmative duty to reply to those pro se persons, which is what it usually is.
Oh, yeah.
To tell them, you need to appear.
Yeah, I'm thinking more the matter of correspondence with the lawyer for the personal representative. I mean, what do we mean by objects?
Well, it's
Brooks raised the question that a will contest, which is an objection to a will or the appointment of a PR. I don't know that it's not denominated as an objection, and so we need to make sure that we're clear what we are talking about here, because we do have other things that we call objections.
Well, this is Jennifer. Would it work to just say to which any other party has filed an objection or
contest?
Or requested alternate relief? I mean, I think the language is fine, but I understand why you're concerned.
Yeah. Object here is sort of the way objected in this draft is sort of a colloquial objected, and we have specific things that we mean.
This is Rita. I kind of like the alternative relief. I'm thinking of the scenario where I haven't gotten an accounting filed. I'm issuing a show cause order and appointing counsel for the minor child who's the heir. It's kind of me making the thing move forward, and
Rita, I lost you after.
Sorry, it's the show cause is one of the things that the court would start what's going on here and cause the litigation to move forward.
Well, so this is Jennifer, and maybe what you could do is say to which any other party has filed an objection or a party or the court has requested alternative relief.
Yeah, I think we're all in sync with the policy. It is a question of just the language to make sure that we describe it so that we describe it correctly. And try that again, Jennifer. I think that sounded pretty good.
So it would be to which any other party has filed an objection, or a party or the court has requested alternative relief.
This is Mark Comstock. The term alternative relief, again, is a bit undefined.
Yeah.
I'm looking at ORCP 18, and it says a pleading which asserts a claim for relief, whether an original claim, counterclaim, cross-claim, or third-party claim, shall contain plain and concise statement. So if we use the term claim for relief, does that advance certainty maybe?
So, and this is Judge Burton. I'm just not sure that, or the court requesting alternative relief, addresses the scenario that Judge Cobb was talking about where the court issues a show cause. I mean, maybe we just want to specifically say, or the court has issued any kind of order requiring a response to which a person has responded.
Lorianne, are you picking up on this conversation? And I'm wondering if we can maybe leave it to you to draft the words for us to look at in that draft that you put together.
Yeah, I can wordsmith this a bit and have some proposals in this draft for y'all to take a look at.
Okay.
Mark,
So it sounds to me like we want to capture something like a will contest, or in anything that would be not denominated an objection, or something that seeks relief that's, I'm not sure, alternative sort of suggests there's something else, and we're not saying what that something else is, what it's alternative to.
Mark, could you read 18?
Sure. A pleading which asserts a claim for relief, whether an original claim, counterclaim, cross-claim, or third-party claim, shall contain, and then sub A is, a plain and concise statement of the ultimate facts constituting a claim for relief without unnecessary repetition. B is a demand for the, a demand of relief which the party claims. If recovery of money or damages is demanded, the amount thereof shall be stated. Relief in the alternative or several different types may be demanded. I was focusing on the claim for relief term because it is generally understood, I guess, as opposed to the adversarial relief or alternate relief, excuse me.
Yeah.
Well,
go ahead.
This is Jennifer, and I guess one thing I wonder is, do we really want to trigger all of this extra complexity if the court has simply said, I need you to come in and tell me what's going on, or I need you to file an accounting or whatever? Is that really, do we really want to go to this next level for that, where it could just involve the fiduciary?
So this is Judge Burton. So I could envision in that situation, rather than issue a show cause, the court says, hey, I'm setting this for a status conference and you need to show up and talk to me in person and tell me what's going on. And I agree, I don't think you necessarily need to trigger all those ORCPs. But if I issue a show cause that says, hey, I'm going to remove you or I'm going to surcharge you, then I think that's an adversarial proceeding.
Judge Burton, this is Lorianne. So are you saying that if the court calls in a fiduciary to explain to the court what's going on, that would not trigger this, these additional,
right, that's my thought, is that if the court hasn't issued a show cause, if the court has just said, hey, come talk to me, I'm not proposing any particular action. I'm just saying I want information. Whereas if I issue a show cause order, I'm saying, hey, here's what I'm going to do if you don't persuade me not to, and I'm going to issue some kind of order or judgment.
And this is Judge Cobb. Claudia, you and I both know that at times our show cause orders causes this whole cascading effect where the other people show up and say, and, you know, and it starts this whole litigation that goes on.
Yeah, that can certainly happen.
All right. I think we've described the scenario. I'm inclined to leave it to Lori Ann to kind of distill this as best she can, so that we have words that we can react to in our next draft.
Works for me.
Yeah, unless somebody has another just policy concept they want to offer here to help further refine this for Lori Ann. So we know it's an objection. We know it's a contest situation. I agree that the court-initiated ones are a little bit harder to describe, mostly because they don't have a lot of experience in them, probably, thankfully.
This is Jennifer. The other thing that comes to mind is that the PR has the ability to get the court to help them force people to provide information or turn over assets. And so I would think that would be an adversarial litigation.
Good point.
This is Lori Ann again. So would petitions for instruction fall under this?
I think they would. Sorry, this is Claudia. I think they would if somebody responds to them, because then you've got a fight.
This is Brooks. That's exactly my view.
Yeah.
Once you get outside the objection period and there are no objections, it remains administrative because you have no opponent.
That's good. So again, Brooks, back to your comment earlier, this is triggered by somebody doing something, somebody objecting, somebody seeking some relief, and that's a description of that, where you may have a petition for instructions that get issued. You would serve that on the other interested parties in the case, but if nobody themselves initiates anything in response to that, then we're not into this ORCP situation.
That would be my exact view and what I would expect.
Okay. All right. Let's go on to B on the top of page 5. For the purpose of applying ORCP, the use of the word plaintiff includes any party asserting any claim for relief. There you are, Mark.
Yep.
Whether by way of petition or motion, and defendant includes. So these aren't really definitions; they're descriptions. They're inclusive, so they're not. It's not an exclusive definition. What are we doing here?
Well, the purpose, this is Jennifer, the purpose for that was the ORCPs refer to plaintiff and defendant. We don't have those terms. Yeah, so it's just simply to make it fit with what we've got in probate.
So in whatever we do in sub A, I think we'll want to do in B. So for instance, not just the party asserting a claim for relief, but a party filing an objection, or whatever it is that we're saying in A triggers. I think we'd want to incorporate that into B.
That sounds
reasonable. Objection isn't necessarily asserting a claim for relief, I don't think. Or else we need to say petition.
We lost you there, Lane.
Oh, I'm sorry. I was just saying that what we got here is we define plaintiff or describe plaintiff as asserting a claim for relief by way of petition or motion. And I was just saying that whatever we describe in B should reflect what we do in A. So it may be an objection, and they may not be. Yeah. So B is just a little bit. We just need to be cognizant to be with what we do in A.
And I agree with that.
And figure out, make sure we understand who's the plaintiff in something initiated by the court.
Yeah.
Although again, since we're saying includes, it's not really defining.
Yeah, I think the court is just the court.
Right. You don't want to be defined as a plaintiff?
The court
I
has
do not.
the court has certain inherent powers,
Right.
one of which is show cause or whatever.
Right. Okay. Well, again, I think A and B will need to come back together, but the concept is right. We need to make plaintiff and defendant in the ORCP connect somehow to what we're doing in Chapter 111. That makes sense.
So this
So
is Lorianne, just
two,
to
the
make sure
court
that I
shall,
understand.
at every stage, disregard any error or defect in the pleadings or proceedings that don't affect substantial rights, liberally construed, toward substantial justice between the parties.
Explain this, John.
Yep.
Should substantial rights be substantive rights?
Yeah, where's that language come from?
I think that comes from ORCP. I'm looking for it at the moment.
So, but then you also have ORCP 68, which is like, if you didn't plead fees, too bad, so sad.
But of course, 68 is one of the rules that applies in sub 1.
Right.
So I think that would still.
But I mean, I guess that contradiction already exists in the ORCP, so we're not creating it.
Yeah, Judge, this is Brooks. 68 provides both the sword to knock out a fee claim that wasn't preserved and the shield to preserve your fee claim. So I don't think that contradiction is a problem here. It lives in every civil case.
Yeah.
Yeah.
So John's question is it substantive or substantial rights? And I guess if the ORCP has that language, I would just mirror it. And so, Lorraine, you can confirm that, I guess, in the redraft.
It's in Rule ORCP 12B.
Okay. And it's substantial?
Yes, it is substantial.
Okay. So then 3 on page 5, the Oregon Evidence Code applies in probate proceedings. So here, this is not just adversarial litigation, it's in all instances?
Elaine, yeah, that kind of gets to my question. This is Rick. You know, we have a statute already in the code somewhere, I don't recall the number, where our business records supporting a claim that we submit or prima facie evidence. And I just want to make sure that this isn't in some way going to conflict with that statute.
Hey, Rick, this is Brooks. Doesn't your statute make itself an exception that is superior to the code?
The evidence code?
Yeah.
Well, it does. I guess I'm not following you. The evidence code isn't mentioned in that statute. No.
Okay, well.
So, I mean, so the only way you can make an argument, I'm guessing, I don't know. The way you can make an argument is that our statute is more specific and therefore presumably supersedes the evidence code, but I'd rather not have to make that argument. Or am I missing something?
Well, that would be easy to solve with just an except as otherwise provided by law. I don't know, Lorianne, I guess LC doesn't like that kind of a broad exception, do you?
We don't, no.
So we would need to comb the code and find the specific cases Yeah, that's a challenge.
Yeah, actually, Rick, is this a specific statute that you're thinking of?
Yes. Well,
are you
actually,
able
it's a
to?
subsection of a specific section in the statutes.
Are you able to give me a little bit more
115,
information about?
195.
Oh, you guys are doubling.
I heard 115, 195.
Yes.
Well, this is Jennifer, and the way that it's done in chapter 125.050 is it says, except as otherwise provided by this chapter.
Oh.
So you could include that, except as otherwise provided by X, the Oregon
Yeah.
evidence.
That's a good thought. If Lorianne could do that and just recite 111 through 117.
Yeah.
But what about applies in probate proceedings? We're filing an initial petition for admission of a will to probate. Is there how does this relate to that? Because this isn't just about adversarial proceedings. This is broadly probate proceedings.
Well, this is Jennifer, and to tell you where this came from, we looked at ORS 125.050, which says, except as otherwise provided by this chapter, the ORCP and rules of evidence apply in protective proceedings. And I think that's partly why I wanted to use the term probate proceeding, as we're mirroring protective proceedings. And that was why then that definition was suggested.
And Lane, this is Brooks. With respect to admission of wills, going back at least to the Deddy Code and the common law, a will accompanied by an affidavit of at least one attesting witness is admissible in common form, which is by definition an ex parte proceeding, which by definition means you cannot have the rules of evidence applied, because ex parte proceedings don't have people seeing a judge and saying words, which means declarations and petitions are merely hearsay. So I would agree that if that's what this results in, that's going to be a problem, because we got to have a face-to-face hearing for every common form admission. And that's going to create chaos if we draw a line in a will contest. The will contest converts a common form admission into the PR's obligation to then admit the will in solemn form. And what do we do then?
Yeah.
Well, then maybe the solution is to say that the evidence code applies in adversarial litigation.
That wouldn't bother me a bit. This is Brooks, because that would allow the probate judge to say, this is administrative. I just need to know declarations are fine with me. And I think that the court should want that efficiency.
Yeah, this is Claudia. That makes sense to me too, because the other thing is like accountings, all the stuff in accountings is hearsay.
Oh, yeah. Yeah, I'm inclined to think that we need to narrow that to adversarial litigation, if that's the phrase that we're going with. Maybe we go back. Maybe adversarial litigation is a bad term to use in probate. Maybe it's adversarial. I don't know. Litigation is a loaded word there. But who else was going to speak? There was somebody else, I thought.
This is Lorianne. So am I understanding you correctly that basically we're going to limit the application of the Oregon Evidence Code in the same way that we'll limit the application of the ORCP?
I think that's right. Is that the consensus of our group? Okay.
Yep.
Can we go back for just a second there as I look at that in A? Do we want to say litigation?
Could you repeat that, Lane? It got beeped out.
Do we want to say adversarial litigation? Is that a term that we want to incorporate or import into probate? I mean, granted, there is litigation, but do we want to call it something else? Anybody have a feeling about that? We could say adversarial proceeding.
Yeah, that's fine.
Jennifer or Heather, is there any reason that you picked that word? Anything to pick?
I think it's exactly right out of 125. We just modeled the same language.
Well, on the chat box, there was a suggestion of contested proceeding,
Yeah.
which I think is got some clarity.
I think that's a good addition, although I'm not sure that applies well with what a court would want. I guess the court's contesting it, but I like contested better than adversarial because it's a simpler word.
That's, this is Jeff. That's actually how we refer to them as contested proceedings.
Bingo. I like that. I think adversarial and litigation are just kind of freighted. And I don't know why, but somehow I've got a notion that probate ought to be kinder and gentler. Imagine that. But I like contested proceedings.
That comment was from Brian also.
Okay. So Lorianne, we'll do whatever it is that we do in A, it's going to be contested proceeding.
That sounds good.
And then we can use contested proceeding in 3. All right.
So wait. I'm sorry,
What?
this is Rick. I keep dropping out on this thing, so I kind of keep missing pieces. What are we doing on sub 3 now?
We're going to say the Oregon Evidence Code applies in contested proceedings. Do we still need an except as otherwise provided in chapters 111 through 117?
Well, I guess I'm kind of worried about that because, the reason that we had that provision in it in 115195 was because people were constantly challenging our claims. And so.
Well, yeah, I think the intention here is not to override that. We want to make sure we carve that out. And whether we do it generally with a reference to all of the probate chapters or whether we just do it by reference to that statute, if that's the only place of concern, then it would make sense to specify that statute.
Well, this is Jennifer.
This is Gretchen.
Oh, go ahead.
Can you hear me? Oh, okay.
Yeah.
I wasn't sure if I was in or not. As I look at sub 2, it looks like it already has an exemption, notwithstanding ORS 40.460, which is Rule 803 hearsay exceptions and self-authentication. A document is prima facie evidence. So it already in that statute does have an exemption from the evidence code, which is interesting because does that mean that we're already implying that the evidence code generally applies? Why else would that exception be in there?
This is Jennifer. Well, and that's part of the ambiguity that we were trying to resolve with this. I guess I would add, looking back at, again, the model for this in the protective proceedings statute, it does say, except as otherwise provided in this chapter, which might be a good thing in case there are things added in the future if they don't already exist.
That would work for me, and I guess, sorry, Lorianne, you might want to look at what Gretchen just referred to as well to make sure that we're not saying something twice or that we're not saying something inconsistent with what's already in the chapter.
Yeah, this is Lorianne. Gretchen, could you give me that site again that you were reading from?
Yeah, it's still that 115.195. It's sub 2.
Okay.
Thank you.
Lane, this is Judge. I wanted to back up just a housekeeping under the AAA application. Civil procedure applies to adversarial litigation pending. So if we change the adversarial litigation, we should probably do it up there as well.
Yes. Right. I'm thinking too, Lorianne, in this next draft that we get, that maybe a little bit unorthodox, but could you include the entire chapter in the draft, even the parts that are not being proposed for change? I think that would help as we look through this, so that we don't have to be looking back and forth between the chapter either in a book or online.
Yeah, chapter 111 is not that long. I can do
Okay,
that.
good. That would really
Are
help.
there, if there are any other parts of the probate code that you'd like me to drop in there too, let me know and I can do that.
Okay. Well, for the next one anyway, let's just do 111. That'll be really helpful, because we could cross-reference these changes, these sections we're proposing for change, and have in front of us as well what's already in there to make sure that we are being either consistent or avoiding creating confusion between existing current provisions. Anybody else want to say anything about section AAA? I think we've given Lorianne some guidance on that. Then let's jump, well, we've got a little bit more time, to BBB and tell us what's going on there, authors.
Well, this is Jennifer, and one of the things that we were trying to deal with was the current difficulty when you have a minor or financially incapable beneficiary and how they can be represented. And so I believe the law allows the guardian ad litem to do that, and the special representative process under the trust code is convenient and familiar, and so I think we added that. And we also, this BBB was modeled after one of the UPC provisions that I think Susan had provided, early on.
Hey, Lane, this is Brooks. ORCP 27 for guardians ad litem was drafted by the Council on Court Procedures, or redrafted, really with a specific eye towards civil litigation. And it's not a perfect fit in probate land. So I would be relatively strongly in favor of considering importing the special rep concept that we already have in the UTC, and perhaps not even mentioning GALs, but maybe we continue to. Certainly a guardian or conservator already appointed could absolutely represent someone, but if they don't have those, the special rep might be a much more flexible tool for the kinds of things probate courts need.
So this is Judge Burton. So typically if I have, like a minor beneficiary and the mom's the PR and there's a potential conflict of interest between mom and the kid, I've used the guardian ad litem, and I think for the most part that's worked fairly well, but I'm not necessarily averse to adding the special rep, but I'm not sure I would want to take out guardians ad litem. I kind of like to have all the tools in my toolbox.
Well, this is Jennifer, and one of the things about the special rep is that under B02, it says, to the extent there is no conflict of interest between the representatives. So if you had a parent acting as a fiduciary and then the minor child, my view would be that would be a conflict, and so then you would have to find somebody else to represent them, for what that's worth.
Right.
And the other thing is, I really like the simplicity of just having one process. When we're trying to kind of simplify and modernize, especially when a lot of probate lawyers are not that familiar with the guardian ad litem process.
And if you think probate lawyers aren't, try civil lawyers.
My only question is, as opposed to 111,
Lane, could you repeat that? You blanked out.
Sorry. Mia, my question is whether these representative sections, the B series, whether that belongs in chapter 114 as opposed to 111.
Well, this is Jennifer, and in the Uniform Trust Code, representation is in the earlier parts of the statute relating to procedure. It comes right after judicial proceedings, and to me, it seems like more of a procedural thing than a administrative thing. But that's just my view.
And I don't have a strong opinion. I mean, and it's not a question as to the policy, but does anybody else have an opinion about that? Because we deal a lot with appointment, certainly of the personal representative, in chapter 113, and we have chapter 114 is administration of the estates generally. And I don't know, and I can't articulate it, but this seems to have more of a feel of a chapter 114 provision than a chapter 111. But if nobody else.
Yeah, I think it goes in, this is Heather, I think it goes in 111, and the reason I don't think it goes in 114 is 114 is just the general administrative work. It doesn't really include the notice sections, which 111 does. 111 talks about, what was required for notice, et cetera, and 114 talks about what's required for everything else.
All right, like I said, I don't have any strong feeling about it, and if nobody else does, then I'm fine with 111. So, is there anything else in that B series we want to talk about for now?
This is Judge Cobb. Brooks, you said ORCP 27 doesn't exactly fit. So is this the place to smooth off those rough edges and make it clear that the court has the ability to appoint a guardian ad litem?
Yeah, and I hear Judge Burton, and from my days on the Council on Court Procedures, I'm a big fan of expanding the court's power to control cases in its docket. So if we could make this clear that the court is the final repository of the decision as to which of these flavors of fiduciary get appointed, I would hate to be in a position where litigants try to mousetrap the court and say, well, I've only requested a guardian ad litem, you have to appoint that, and you, Judge Burton, think a spec rep would be better. In the same way, in a guardianship proceeding, you cannot appoint someone who's not nominated, no matter what you want to do. I don't like that result here. I'd like you to have the flexibility. So that would just be a language change to make it clear that despite what pleadings are filed, the court retains the final decision as to who gets appointed, what their authority is, et cetera, et cetera. That would really solve that problem.
I love that.
Would it work to say?
Well, I've also,
go ahead.
This is Judge Cobb again. I've been in a situation where I've contacted an attorney. I wanted to represent a minor or a person who lacks capacity, and I've actually given them a choice. Do you want to be the attorney for this person, or do you want to be the guardian ad litem? Do you want to, and kind of based on what they want, I've acquiesced because I want somebody to helping out this folk.
Right.
It's getting harder and harder to be, I think the lawyers and the courts need to really think about whether they want to be the attorney for whatever that incapacitated person is, because it kind of narrows the scope of what you can do for them versus what you can do as like a GAL or a special rep.
Exactly.
Right.
And that's why I've kind of given them the, option of, okay, what do you want to be?
Well, this is Jennifer, and I think
That
that
doesn't bind the court to do that if the court thinks a guardian ad litem would be a better way to proceed.
So one concern this raises for me is I don't want, if the lawyer is kind of taking the lead and saying, okay, we need to have a representative for this person. You know, I don't want the lawyer to say, I'm going to try to appoint a special rep and go to all that trouble and paperwork, and then the court say, no, I'd rather have a GAL. So I would like their, you know, I mean, I could see a point where the court says, you know, time out, we need a representative, and the court should get to decide that. But if the lawyer's trying to kind of anticipate that need, because somebody has to get notice or something, I want the lawyer to be able to not get second guessed.
Judge Burton, it sounded to me like you were kind of a fan of the court having that plenary power.
Yeah.
Well, so then does the lawyer need to contact the court and ask the court what mechanism they prefer before filing a process?
I mean, they certainly can, and I think, you know, various different courts may or may not be more responsive to that. I mean, I have never actually had a situation arise where somebody said, I want a GAL, and I've said, you know, no, you have to have something else. So I don't have a specific thing that I can point to you and say, here's why. I just, in general, like having options because, as we all know, stuff comes up that you hadn't anticipated or seen before.
Would it work instead of where it says at any point in the proceeding? Could we instead say on motion of a party or the court's own motion, the court may appoint?
I like that.
And this is Judge Cobb. Jennifer, I'm kind of reiterating what Claudia just said, that I have never, in my memory, come across when somebody says an attorney has petitioned for example, a special representative. I've said, no, I know better. I've granted that. My example was mostly when I'm trying to get somebody to represent the interests of an incapacitated person, I'm trying to be as accommodating as possible and giving them enough so that they'll agree to do it instead of saying you're going to be this GAL or a special representative. I'm kind of asking them what their preference is as opposed to opposing somebody who says a special representative needs to be appointed.
This is Mark.
Right.
Oh, Mark, go ahead.
A careful lawyer is probably going to plead alternatives. So going to plead guardian ad litem or the special representative, and the court certainly would have the authority to grant such other relief as is just and equitable. So I don't think there's a problem with Triple B as it's kind of identified now.
The difference between a special representative and a guardian ad litem, regardless of the procedure, is a special representative is required to have appropriate skills and experience necessary to adequately represent the individual. So it means oftentimes like a lawyer or a fiduciary or a trust officer. That's not true with the guardian ad litem. That's a big difference between those statutes.
Doesn't that just then kind of define what the court needs to inquire of the proposed appointee?
Well, that's where I'm thinking if we do say on motion of a party or the court's own motion, number one, like the example Judge Cobb raised, somebody may not be asking for it. She may just be aware that there's a need here. She's going to do it. Or if somebody has filed a motion for a special guardian ad litem and the judge in that case says, no, we need somebody more special than that. We need a special representative. The court can say, I'm using my authority on my own motion to appoint a special representative. It seems if we use that language on motion of a party or the court's own motion, I think we've opened up that opportunity in all cases.
I've got no problem with that addition.
Okay. We good with that?
Well, this is Jennifer again, and I guess my only concern is this is one of those things where it may be that every court.
B01, B02 as we go.
I'm sorry, I missed that. My concern is that we might have 32 different courts doing this 32 different ways, or you know, you have to know which court is doing it which way, and it's going to maybe disincentivize the GAL for a family member because you're going to apply for both, and then you're going to have somebody who qualifies as a special representative. To me, it's more complicated when you're moving to do this.
Well, I'm not suggesting you need to move to do it. No.
Jennifer's point is that for lawyers trying to figure out what to do, yes, you can call the court, and in the metropolitan counties, the court staff know what you're talking about. They don't always know in the more rural counties what the distinction is. So Jennifer's point is, if you go to because having a GAL appointed under OR CP 27, it's a much more significant process. So, you know, I think that that's going to be lawyer discretion, and people are going to have to use good judgment. If you have a case where you think that there's going to be something funny, you're going to have to use good judgment, and that's probably something that the commentary to this section should talk about.
So this is Claudia, and I think as a lawyer, you know, you're always going to ask the court for what you want or what you think is best, and sometimes you're going to be unsuccessful. I mean, there's nothing anywhere where there's a guarantee that, you know, if I file this particular motion, it's going to work.
Glenn, this is John. My question is, what's the problem that we're trying to solve here?
Oh.
We already have guardian ad litem availability. I think my understanding why we have special representatives in the trust code is because you need somebody to act on behalf of a beneficiary when you don't have a contested proceeding, and there's no way to appoint a guardian ad litem. So to bring that into the probate situation where you have a contested procedure doesn't seem to be necessary. You've got the guardian ad litem availability
but you don't always have a contested proceeding.
Right.
I mean,
Well,
I've had plenty where it's like, we've all agreed on this settlement,
Yeah.
and I'm like, but yeah, the kid, and you're the potentially liable driver, and yeah.
Yeah,
Well,
okay.
this is Jennifer, and the scenario I'm thinking of is the sole beneficiary of the estate is a 10-year-old. And how is that 10-year-old going to have meaningful notice?
Right.
No, I think there's a good case to be made for the special representative. I guess the question is whether, I think if there's any disagreement or divergence here, is whether if I ask for a guardian ad litem, I get a yes or no answer, or whether if I ask for a guardian ad litem, the judge can say, no, but I'll give you a special representative.
Well, and I think this scenario, I'm sorry, this is Judge Cobb. I think the scenario is, and I've seen this frequently, is that, you know, we're going to have grandma who's 85 as the guardian ad litem, and I'm looking at the conservatorship, or I'm looking at the estate, and, you know, we've got, you know, $900,000 here. And my question becomes, well, wait a minute, is this really appropriate?
Right.
This is Lorianne. Is this limited to probate are we talking about just probate proceedings with respect to wills? Or, because I'm not.
Go ahead.
I'm not seeing in here that it's really clear that it wouldn't apply to conservatorships or guardianships as well.
This is Judge Cobb in small estates.
Yeah.
Well,
this is Jennifer, and again, this is another reason why you might want to define a probate proceeding to not include Chapter 125.
yeah.
The issue is that right now what we're seeing happening is people are sending notice to like a minor heir or a minor devotee parent, knowing that the person is a minor, never mentioning it to the court, never doing anything. And so there's some challenge about is there a cost-effective way to manage this situation? I think that half the time that the lawyers aren't disclosing to the court in probate petition what the ages of beneficiaries are.
But Heather, to answer Lori, to get to Lori's question, we do intend this section on representation to apply in probate proceedings.
Okay, that helps me.
Right? That was a question. But I think so. Folks, it's coming up.
Probate meaning
Oh, what?
estates?
Oh, go ahead, Claudia.
Probate meaning decedent's estates? Is that
Yes.
what you mean?
Yes.
Okay.
Oh, yes, thanks. All right, it's coming
And
up
is that
soon. Judge Cobb?
Does that exclude then small estates?
Ooh,
Well, those aren't proceedings, are they?
those aren't proceedings, that's right.
Well,
We learned that last interim.
Well, this is Claudia. I mean, typically they weren't. They were just open and closed. But with that new legislation, there's a lot more ability to hold hearings, and you can remove affiants. And
that's true.
Exactly. That's my point.
This is Jennifer, and if you look back at the proposed definition of probate proceeding, it would clearly include Chapter 114 and small estates.
I think what we need to think about here is whether there are places in this section in particular, maybe we go into 114 and we exclude them because in the small estate sequence. Let's think about that as we come back to this. And that's a good question. To what extent is this going to apply? And I think we need to think of that in all of the things we're thinking about in 111 to make sure that we have small estates in mind. Because some of this probably will not apply to small estate proceedings unless you are in a situation where, as Judge Burton said, you've got a hearing that's something filed that's going to generate a hearing. I want to go ahead and wrap this up for now. Where we are then is we asked Lorianne to come back with a draft of Chapter 111 that will incorporate the changes proposed in this draft that we have before us this morning. And Lorianne, if you would, in your draft, reflect the changes that we've made this morning in our conversation so that we're not starting over again. And then we'll just pick up at our next meeting and keep going through this. We know how to do this. Any preferences for 2 weeks, 3 weeks, a month from now? We have, of course, through the end of until December probably to get this done. I hope we don't have to take all year to do it, but our folks would be more inclined for 2 week or 4 week break at this point.
Lane, this is Christopher jumping in on Kathy's connection. I thought we had the e-wills on the docket for this so that we could address potentially having those go in front of the special session and get us something useful during the time when we can't talk to anybody or see anybody in person. And so I would vote shorter period and skipping to the more temporally relevant statute.
Interesting. Yeah, actually, that's not a bad suggestion. What I heard this morning is that the special session, if there is one, it may come after Easter. It may come as far into May. So I don't think we're going to see one in the next couple of weeks. I think May is probably more likely if we have one. If we were to go on the 15th, would folks generally be okay with that if we take up
Lane, Lane, this is Sandy. I could send a scheduling link if you like for somewhere around the 15th.
Sure. Let's do that. Let's do a doodle poll. And
yeah.
I like that. I suggested Chris to take up the e-wills. That's timely. It may be something we can do in short order. It may be too big a lift to get done in a special session, but it's worth at least going through it and seeing where we are.
Susan, were you going to try to say something?
Yeah, I was just going to say, so I've been on, I joined about 10 minutes late, but didn't have anything particular to say. I've been taking notes.
Okay.
And with respect to e-wells, I think that's a good idea. I had suggested to Lane that we didn't need to start there because I don't know that we'll be able to make decisions on e-wells in time.
Right.
But now that we've got a little more time for the special session, I think it makes sense to do that. And my one request is, because I teach Mondays and Wednesdays, this Thursday slot, if that works for other people, is really good for me.
Generally works for me.
Yeah, I'll put it
let's
out
shoot
for
that.
Thursday.
I think it'd be fun to take up the e-wills, and we may just breeze through it and say, "Damn, that's a good act. Let's just adopt it wholesale." Or we may just run. Yeah, or we may just run into so much to talk about that we realize it's going to take more time. But I'm
Lane, I will say anecdotally, we've received several calls and inquiries into the commission about including e-wills in the special session. I've told them at this point there were no plans to, but that's something of interest, various firms.
Oregon Law Commission to the rescue.
We'll try.
Linda, will you bring your cat to the next meeting?
Only if I can bring.
Stay healthy.
Only if I can bring her brother.
All right.
Lane, this is Claudia. I believe I'm not actually a member of this, but I would sure appreciate.
Put you on the distribution list.
Yep.
That would be fabulous. Thank you.
Yep. Okay. Stay healthy, everybody.
Thank you, everybody.
Thank you.
Thank you.
Thanks.
Thanks. I dropped my phone.